Good afternoon, everyone. My name is Guillermo Patino, the chairperson designee of the New York City Loft Board. Welcome to our March 21st, 2024 public meeting. Section 282 of the New York State Multiple Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of interim multiple dwelling units, from commercial and manufacturing spaces to legal residential units that comply with the minimum standards of safety and fire protection in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of legalization, and prosecutes parties who violate the loft law and the loft board's rules. Before we get into today's agenda, I would like to welcome a new fire department representative who will serve as an alternate to Mr. Roche, Chief Peter Archer. Mr. Archer is a 29-year veteran of the fire department. He has been a chief officer since 2014 and is assigned to Battalion 8 in Midtown Manhattan. He has previously served as a firefighter in Manhattan and Brooklyn, a lieutenant in Engine 6 in Lower Manhattan, and a captain in Engine 279 in Brooklyn. He's a native New Yorker and a graduate of the State University of New York at Albany, and presently he's serving in the Bureau of Fire Prevention as the Chief of Technology Management. We'll first turn to... Thank you. We'll first turn to vote on the minutes from the February 15, 2024 public meeting. Are there any comments or corrections to the minutes?
Yeah, you reported last month that the fact sheets are now live on the website. What are the next fact sheets that are going to be
Sales of rights that appear.
okay. I'd like to lobby for thinking about a letter of no objection as well.
So we did that.
Did we?
I think so.
I didn't see that.
Okay, I'll take a look.
Okay. And that's it.
Thank you. Is there a motion to accept the minutes? Thank you, Mr. John. Is there a second? Thank you, Mr. Bowers. Mr. Mayor, can you please pull the board members?
Mr. Bauer,
Yes.
Chief Archer, Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Addo,
Yes.
Ms. Rajan,
Yes.
Chairperson Patino,
Yes.
6 in favor, 1 abstain.
Thank you. Next, we'll have a presentation from the Department of Buildings Office of the Tenant Advocate, as discussed at our last meeting. And we have Anna Puccinata and Zangji Khan from the Office of the Tenant Advocate to present about tenant protection plans.
Hi everyone. Hello.
Hello.
Hello. My name is Anna Puccinata. I am a tenant liaison over at the Office of the Tenant Advocate with the Department of Buildings.
And my name is Amji Zain. I'm the Assistant Chief Plan Examiner over with the Office of Tenant Advocate.
All right, thank you for having us here. Just a short presentation on what a tenant protection plan is and what our unit handles.
These questions were presented to us previously, and it goes according to the list that was presented to us. So if you guys have a list, it goes according to that list. What is a tenant protection plan? A tenant protection plan is a narrative that explains in detail what the contractor will do to protect tenants. A tenant protection plan is a narrative that explains in detail what the contractor will do to protect tenants in the 10 essential elements. So the following is a list of those elements. List all units that will or may be occupied during construction, egress, fire safety, health requirements, lead and asbestos, compliance with housing standards, structural safety, noise restrictions, maintaining essential services, and other requirements as applicable. Next question, when is it required? A tenant protection plan is required whenever any dwelling unit remains occupied during alteration, partial demolition, and construction. The tenant protection plan is required even when residential space is not within the proposed construction area. For example, work on commercial spaces in a mixed-use building. question is, when did it become a requirement? The tenant protection plan has been around for a while and has changed for the better. The tenant safety plan dates back to Directive 1 of 1984. In 2008, the tenant protection plan was first included in the building code. Changes to the tenant protection plan required by a handful of laws in 2017, 2019, and 2021. In DOB now, the tenant protection plan online fillable form has expanded to 10 elements. It was previously 7. Explain how it has evolved over the years. Local Law 154 of 2017 reformed the tenant protection plan and set mandatory inspection requirements by DOB. Local Law 106 of 2019 shifted the requirement to file the TPP to the architect or engineer hired by the GC, and it increased inspection mandate to 10%. Local Law 116 of 2019, the TPP is submitted prior to permit as opposed to prior to approval. Local Law 118 of 2019, the tenant protection plan requires both owner and applicant signatures. Also increases penalties for failure to file a TPP to $10,000 for first offense and $25,000 for subsequent offenses. Explain how it changed in 2022. Local Law 40 of 2021 enhanced lead-based paint requirements in TPPs. The law went into effect on November 14, 2022. Local Law 126 of 2021 added the special inspection requirements for projects that require a TPP. The law went into effect on November 7, 2022.
Excuse me, can I just interrupt 1 second? We have a lot of people who are watching this virtually, and just so they know, I have a person who lets me know how we're doing. The screen is brightened out, so it's not readable to the people attending virtually. So I just wanted to let them know that what they're hearing is what we're seeing on the screen.
Okay, yes.
Sorry for that.
No problem. Next question, what is the role of third-party inspections? Third-party inspections for TPP are conducted by a qualified special inspector. The special inspector is required to be independent of the contractor. The owner hires the special inspector to inspect construction at regular intervals, weekly, to ensure they are compliant with the TPP.
Just a little blurb as to what the Office of the Tenant Advocate is. The Office of the Tenant Advocate, or OTA, at the New York City Department of Buildings is a unit that advocates for tenants internally within the Department of Buildings for construction-related complaints or other issues under DOB jurisdiction, including permit filings, service restoration, or DOB filings are necessary. What is its role? The Office of the Tenant Advocate investigates complaints of construction as harassment for work that requires a DOB permit. We also work with the Tenant Protection Inspection Unit to inspect for Tenant Protection Plan compliance, or TPP compliance. OTA staff also facilitates access during vacate orders and provides DOB-related information on service interruptions. OTA also coordinates various investigative and informative initiatives on major cases and represents the department on the city or state tenant harassment prevention task force that investigates allegations of tenant harassment across an owner's portfolio. A little continuation of our role.
Set it to the page.
Sure.
There, thank you.
OTA partners with other city and state agencies to investigate tenant harassment. DOB supports their actions and any potential lawsuits, but does not commence litigation itself. Other agencies also have dedicated units, such as HPD's Anti-Harassment Unit and the Tenant Protection Unit at the New York State Division of Housing and Community Renewal, and the Mayor's Office to Protect Tenants. OTA has a team of plan examiners who perform proactive inspections special audits of tenant protection plans filed for work in occupied residential and mixed-use buildings. When is it appropriate to file a complaint with the Office of the Tenant Advocate? Whenever there is active construction work in an occupied multiple dwelling or mixed-use building. We often receive calls that do not necessarily pertain to our unit's operations. However, we will do what we can to help guide tenants in the right direction to make sure that they get the assistance that they need. Is there a specific type of complaint that should only be filed with OTA? Complaints regarding violations against the Tenant Protection Plan, or TPP, and disruptions to essential services should be reported to our unit. How do I file a complaint? Tenants can call or email our unit directly. Our unit information is made available on the DOB website. They can also call 311 and the dispatcher will transfer their call to our unit. So this is our office line. It's 212-393-2949. And our email address is tenantadvocate@buildings.nyc.gov. And on the Department of Buildings website, there is a frequently asked questions section where it has a whole bunch of information related to tenant protection plans. And that's it. Thank you all.
A few questions for the OTA team. Anybody have questions?
I guess first, thank you. This only came up last month, and I want to thank both the board, staff, and you all for being able to. Sometimes when we ask for someone to speak with us, it takes 6 months. Secondly, I'm advised there are about 30 people watching this virtually, and we haven't had this many people in the public meeting for over a year. The last time was for a hearing, actually, where people get to speak. Here they can't. So my first question is, under the fine structure for failure to file a TPP, has anyone ever been fined?
For failure to file?
Yes.
Yes. So we can sometimes get complaints from the public where they notice that the PW1, which is a plan work application, the owner or whoever filled out the application stated that the building was not occupied or will not be occupied during construction.
Heads are nodding behind
Yes.
you.
So that question on the PW1 application is what triggers a tenant protection plan. So when they say yes, the system will automatically make that a requirement for prior permit. When they hit no, obviously the tenant protection plan is meant to protect the tenants during construction. So if the system is told that the building will not be occupied, then that requirement would not appear.
I'm just wondering if people who are participating virtually can hear the answer.
Should I go to the mic?
I think that would be helpful, yeah. Because again, you know, it took I live in a 4-unit building, 3 of which were initially protected. It took roughly 30 years for my landlord to succeed in completing the necessary work to get a certificate of occupancy. Now, a lot of the buildings that are covered are much bigger buildings. And we've started to see what someone referred to me a couple of years ago as the kind of weaponization of code compliance work. So we're getting a lot more complaints about egress being blocked, doors not being locked, dust, dirt, all kinds of stuff. And I know the board staff will bear me out of this. So the tenant protection plan gets filed, but it's not like an an alteration plan, it doesn't get approved as such, it's just received, correct?
No, it gets reviewed. When
Well,
we file a TPP, it goes through the same, there's a bar across the top in DOD now. It tells you where in the process your various applications are. And there is a milestone for review, like acceptance, review, and it keeps going. So somebody looks at it, or at least the computer is telling me somebody looks at it.
Well, there was a change. So as my colleague mentioned in the presentation, there was a time where the tenant protection plan was a requirement prior to approval, meaning that if the application in and of itself was filed as a standard application, meaning that it goes through the plan examination process, then the TPP was reviewed by a plan examiner at that time. There was legislation that changed that and made it a prior to permit item, which there is some review, but it's not a thorough review like the plan examiners do now with the special audits. So a special audit would be the result of, say, an inspector issuing, going to the site, finding a violating condition against the tenant protection plan, issuing a violation for inadequate tenant protection plan, and then we refer that over to audit. So that is where the review process kind of kicks in.
Right, to that point, maybe you could talk a little bit about some of the thresholds. Even though it's called a plan, and one might assume that it's a drawing, but it's not. It's really just a paragraph. It's the checklist, right? So the contractor certifies basically that he will not block the egress. He certifies that he will mitigate the dust. Go through the items. So it's really sort of like a one-page written summary of what the plan is to do, not a plan. But on larger projects, I believe plans are submitted that show if there's a temporary wall blocking off this part of a floor. So these 3 apartments are being worked on there. These 2 are not. This side has access to this elevator. This side had access to this elevator. There's a connecting door, so they both have access. And you're taking construction materials in and out through the loading dock, not through the lobby. So depending on the complexity of the project, the TPP can be a couple paragraphs, or it can be several drawings.
Yes, that is correct. So tenant protection plan, I understand it might be a bit misleading because the plan word. In the industry, usually plans or drawings. But in this case, the tenant protection plan is actually a narrative that the contractor had hired an architect or registered professional to list out what they're going to do to protect tenants during construction. So they are actually writing it out. Unless they are doing complicated changes to the plans in terms of egress, where it's hard to explain in narrative, then we recommend them to submit a plan drawings to supplement their narrative so that it's easily understood. Otherwise, we do not require them to submit plans, physical drawings. Tenant protection plan narrative is usually sufficient to explain 90% of the jobs out there.
And then can you add a little bit about posting notices and how then the tenants who are meant to be protected know that there's a TPP and where they can access it?
Yes, they are required. I believe it's listed in the code. It's required. They need to post them at each stairway, the tenant protection plan, and they can also request it. It's request the owner for it if there's a tenant protection plan that's in file. Because if they are doing construction and there are tenants living there, even if there's one tenant living in there, residential tenant, they have to submit a tenant protection plan. And they are made aware that it's available and that the tenant can request the owner to provide that for them.
Just if I may add to that a bit. Just so everyone's aware, the actual tenant protection plan application is not what's required to be posted. There is a tenant protection plan notice that is the requirement to be posted. And as Dawn said, she's exactly correct. It needs to be posted on each floor within 10 feet of every elevator or stairway.
I went to a party in a rent-stabilized apartment, and it was the first time I'd seen a tenant protection plan sign, and they were everywhere. I was very impressed.
That makes me happy.
But because this is not a public hearing, the members of the audience are not allowed to say anything, but I guess they can probably raise their hands. Are those of you that have work being done now, are there tenant protection notices posted? You can also shake your heads, yes. That's also permissible. No. Okay, I think.
Let me put my contact information back on the screen.
And will you?
Please reach out to us.
Will you provide the board members with a copy of the presentation?
Oh, sure. Can I email it? Yeah. I'll figure out how to get it out,
Great.
yeah.
Because again, I think there's a lot of concerns here. I'm glad that 311 does refer to you. That was going to be one of my questions. And I understand that an owner's professional can modify the plan.
Yes, I think so, right? What do you mean by the owner professional?
Whoever the architect or design professional, whoever drew up the plan.
Are you talking about the tenant protection plan?
Yes.
Yes. They can modify, they can go in and change the tenant protection plan, yes.
Here, Chuck, I took a picture of our notice the last time I was on a job site.
Yeah, that's exactly what I saw.
Yeah,
Yeah,
yeah.
I was very impressed. I took a picture too.
It really just says, notice, there's a tenant protection plan.
There's also a sample on our website if you guys are curious to know what it looks like.
My next question is process-oriented. Are you familiar with the way, because obviously in a regular apartment building, theoretically, if it's built anew, the work is done, the certificate of occupancy, or at least a temporary certificate, is issued before anybody moves in. But clearly, you have buildings where somebody's renovating an apartment or a group of apartments. But by definition, all inter-multiple dwellings have people living in them when the work is done. So to help facilitate the dialogue between the owner and the tenants who are in occupancy, the Loft Board holds this event called a Narrative Statement Conference. Are you familiar with that? No, okay. I think it's important just to summarize that briefly so they're aware of how that fits in.
Sure.
Would you like to do that?
It is a time when the owner and the tenants, after the owner has filed the alteration type 1 application, what gets filed with the Loft Board is a narrative of the work described on the actual plan. Okay, the plan and the narrative are filed with the Loft Board. The narrative is served on the tenants. So we bring the parties together in a conference room, and now since COVID, virtually also, to discuss this plan. Okay, and out of those discussions, changes can happen. Most of the time, changes happen. Okay.
For the better, I hope.
Yeah, it depends who you talk to.
I was just going to say that.
And so, if I can, as a tenant, once I see the sign that says there is a tenant protection plan, I can find a copy of it, correct?
That's correct.
Yeah.
And you can also request it. It is a requirement for the general contractor or the owner to provide you with a copy form.
Well, that's a good question. So most people don't have access to DOB now. Is it under the application on BIS? On the BIS?
It depends. So the Department of Buildings has two databases. One of them is being BIS. That's where you'll find like our older application. The second one is DOB Now Public Portal. You'll find most of the applications, especially now, on that portal. So it is important to check both. A clear sign to know how the application was filed. If it starts with a letter, it was filed in DOB now. So M for Manhattan, B for Brooklyn, X for Bronx, Q for Queens, and S for Staten Island. Is it S for Staten Island? It is. So if it starts with a letter, it was filed via DOB now. So you'll know to look at DOB now. If it starts with a number, it was filed in BIS. So it is important to check both. And yes, the tenant protection plan will be available on both, or at least it should be.
I have a question. So what sort of education is done as far as thresholds so that unnecessary, unfounded complaints aren't made? In other words, how much dust constitutes a health hazard? What, sometimes fire alarm systems need to be shut down. I'm a fire official. That can be done legally. Are the tenants educated as to what actually is a violation and what isn't? I ask this because I've been on many, many complaints, and the vast majority of them are unfounded because the complainant doesn't understand the rules.
Right. So we do our best. We receive phone calls from the general public all day. So we do our best to educate the tenants who reach out. A lot of them are very, very nifty, and they're aware of what the rules are. So it makes our jobs a little bit easier as far as routing purposes and inspection requests. As you know, I don't know what type of information the tenants have or the owners have, kind of passed on to the tenants at the time of construction. But, if they do have a question, they're welcome to reach out to us, and we'll do our best to educate them as best we can.
And we do have inspectors. We do route inspectors out to
I
look.
understand. My question is really before the complaint is given. There are signs everywhere, but do the tenants that you're trying to protect, do they have the information that they know what the thresholds are? Or is it just sort of open-ended and they, fire, I'm scared of fire, I'll be...
Well, I mean, we hope that they are. Our unit specifically, I know that we put out a number of presentations that are available on our website. So we do hope that they're doing their own research. But if not, again, happy to help.
Is there any way that, I know this sounds a little bizarre, that you could put up posters in Soho, NoHo, and elsewhere? Informing tenants that such a thing exists?
We've actually had a commercial. I don't know if anybody saw it. We did have a commercial. We had some advertisements in the subways. So we've done our best to kind of put our information out there. So I hope it was worth it. I hope people saw it.
Thank you.
right,
And
thank you,
really
everyone.
appreciate it.
Of
Excellent
course.
presentation.
Thank you very much.
I'll take it back.
Thank you.
Thank you.
And I'll send you an email.
So next on the agenda is the staff reports. We'll start with the report of our executive director.
Good afternoon. First is personnel. We'll be posting a job notice for a training position, so if you're interested, please apply. Next is litigation. In the meeting materials, I shared a decision in a case brought by the tenants of 72 Warren. The tenants appealed the dismissal of a Supreme Court case challenging the issue of certification for the narrative statement process. The appellate division in this recent decision affirmed the dismissal. The court found that the tenants failed to exhaust their administrative remedies prior to filing the underlying Article 78. Earlier this week, we received another decision which was distributed today. You have the hard copy, board members. This decision involved 517-525 West 45th Street. The owners of the building brought a second case against HPD and the Loft Board, seeking the cure completion certificate from HPD. In the first case, the court dismissed the mandamus proceeding, finding that the decision to issue a certificate involved a matter within HPD's discretion. In the second case, the owner raised a breach of contract claim, and based on the doctrine of res judicata, the court dismissed the case, finding that the owner should have included the breach of contract claim against HPD in the first case. Lastly, the staff has a resolution for Terry Ryan, so please, before you leave, you can sign it so that we can frame it and present it to her very soon. That's my report. Any questions? No?
Thank you. So next we'll have Ms. Story, who's going to present on enforcement and legalization matters.
Thank you, Chairperson Patina. Okay, with regards to legalization, we have conducted 3 narrative statement conferences since the last board meeting. 7 narrative statement conferences have been scheduled for February, late March and late April. 2 requests for narrative statement conferences are pending currently. We've also issued 3 certifications. With regards to enforcement, we are still reviewing all open enforcement cases for further action. Come on, I'm waiting for you. You know, you're all time.
Any updates on 255 18th Street?
Yes, I have an update. So the violations that were issued, the re-inspection has not happened for all of the units, but he re-inspected 3 of the units for the heat violations, and none, it seems as if the condition was corrected in those 3, and the other 2 still have to, he needs access. So we're still in contact. Okay?
Anything else?
I don't think so.
Okay. Nothing for you, Ms. Nazarino? Okay. Thank you, everyone.
Because you're doing a great job for a minute.
You're getting very authoritative.
I'm one from the back.
So we'll now turn to vote on the case on the reconsideration calendar. There's 1 case on the calendar. It is 1127 Ariel Place in Brooklyn, docket number R0391, and Ms. Story will present the case.
Thank you again, Chairperson. The reconsideration application seeks to review order number 5172, which denied the coverage and protected occupancy status. The basis for the review is an error of law and discovery of probative, relevant evidence which could not have been discovered at the time of the hearing despite the exercise of due diligence. On the issue of error of law, it was argued that the 2005 certificate of occupancy was not dispositive on the coverage and the protected occupancy claims. However, the New York City Charter is clear on this issue. Section 645 of the Charter indicates that a certificate of occupancy is binding and conclusive on all agencies unless it is set aside by the Board of Standards and Appeals or a court of competent jurisdiction. Here, the certificate of occupancy was not revoked nor set aside. As the certificate of occupancy remains in full force and effect, it is binding on the Loft Board. There is no authority to find otherwise. On the issue of discovery of probative, relevant evidence, which could not have been discovered at the time of the hearing, it was requested that the record be reopened to submit evidence about several existing violations issued against the building. While the conditions described in the violations represent conditions that must be addressed, there is no basis in law for the proposition that the mere issuance of the DOB violations invalidate an existing residential certificate of occupancy. The proposed order finds that the order number 5172 was supported by the evidence in the record and denies the reconsideration application.
Thank you. Are there any comments on this case?
Yes, I would just reiterate, I plan to vote against this as I voted against the underlying motive. I think there's expertise of the Loft Board is such that there are a number of questionable circumstances around this building, including the fact that the certificate of occupancy was issued for a vacant lot, which some people refer to as a typo, but which might be indicative of other things. So I've done the vote now.
Thank you, Mr. Flanagan. Does anyone else have comments? Is there a motion to accept the case?
Well, I was just going to bring up, so some of the conversation was based around the issue that some of the violations, like had they been present in 2005, would have precluded the issuance of a certificate of occupancy and do present some serious safety issues to the tenants of the building. And the concern that there is some follow through on DOB's part or on somebody's part that these violations are corrected. Can we talk to that point? Is there something to be done? How would something be done? How would some guarantee be given?
We have no jurisdiction.
We have no jurisdiction. My question is, if we table this case, is there any way that we can come back with a better solution? I mean, if the case fails, which it might, without taking a straw vote, then where are we? What will we do?
I defer to the chair.
Huh? What?
I defer to the chair.
What alternative solution do you have in mind, Mr. Barnes?
Well, I don't have an alternative solution. I'm not, I'm a lawyer. I'm not a member of the staff. I just don't know. And I don't know, I went crazy reading all the information on this. The more I read about it, the more confused I get.
And I would argue not to table this case today, because the issue before us is something for the board to decide, and whatever actions DOB took is outside of our jurisdiction. And honestly, there's been violations issued, some of which have been resolved, some of which haven't. But that's again outside of our jurisdiction, so I would argue for us to move forward with the vote.
Mr. Chairman, due respect, I've been in town to the building. I think probably I'm the only member of this board who's been to the building. There are deliberate typos. There are deliberate oversight to paperwork, especially before the digital age. The building department does a really good job. But it wasn't always all filed digitally. And if there's a typo in an address, in a certificate of occupancy, miraculously it falls through the cracks forever. And I have a hard time analyzing the tenants for that sort of, I don't want to say it was deliberate. I'm not even claiming it was the present owner. But it's difficult to, penalize the residents to live in this sort of condition when the building department couldn't possibly do their job because this thing didn't exist. It existed as a vacant lot.
But that's a matter that went up to the Supreme Court, and ultimately it was decided that it was issued an error to the vacant lot, and then that error was addressed by the Department of Buildings.
The Brooklyn Supreme Court, not.
Any further comments? Is there a motion to accept this case?
I'll make the motion.
Thank you, Ms. Rosalind. Is there a second?
I can second.
Thank you, Ms. Rajan. Ms. Rivera, can you please poll the board members?
Lisa Bauer,
Yes.
Chief Archer,
No.
Mr. Delaney,
No?
Ms. Roseland,
Yes.
Ms. Adam,
No.
Ms. Rajan. Yes. Chairperson Patino,
Yes.
4 in favor, 3 against.
Thank you. We'll now turn to the vote on the cases on the summary calendar.
Yes.
There are 7 cases on the summary calendar. 4 cases have been combined on 2 proposed orders, and we usually vote on these as a block. Cases are 657 Fifth Avenue in Brooklyn, docket number AD0134. 482 Broadway in New York, docket numbers LS0293 and LS0294. 304 Mesrol Street in Brooklyn, docket numbers PO0223 and TA0309. 792 Flushing Avenue in Brooklyn, docket number TA0313. And 338 Moffat Street in New York, docket number TR1475. Are there any comments on these cases? Is there a motion to accept these cases? Thank you, Mr. Delaney. Is there a second?
I'll second.
Thank you, Ms. Otto. Ms. Rivera, can you please poll the board members?
Mr. Bauer,
Yes.
Chief
Yeah.
Archer,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Adam,
Yes.
Ms. Rajan. Chairperson Patino,
Yes.
7 in favor.
Thank you. We'll now turn to vote on the cases on the master calendar. And there are 5 cases on the master calendar. The first case is 72 Warren Street in New York, docket number LS0304. And we'll be amending the order. So the last paragraph in the conclusion will be revised to indicate that responsive submissions refer to submissions by the tenant. And also to clarify that the law board staff may grant an extension of 7 days to either party. And Ms. Cruz will present this case.
This is an owner's application for access for probing. Probing involves cutting holes to inspect the inside of walls. After a 4-day trial, the report recommended that the board grant the application directing access to the unit. The proposed order defers the report for further development of the record. The parties are asked to file additional submissions from design professionals. It is not clear from the record whether a permit is required to create these holes in the fire-rated walls. Whether the work requires a permit is essential in determining whether the owner is entitled to an access order. An order directing access for work that requires a permit in the absence of a permit would be against public policy, as it would result in an illegality.
Thank you. Are there any comments on this case?
Yeah, I would just comment that this is a case where we have basically decided not to take the recommendation of the oath law judge and require the owner to demonstrate that a permit is not required or get a permit to do this probing. I think the tenant who represented himself pro se did a very competent job in raising this issue.
Is there a motion to accept this case? Thank you. Is there a second? Thank you, Ms. Otto. Ms. Rivera, can you please pull the board members?
Mr. Bauer,
Yes.
Chief Archer,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Recuse.
Ms. Adam,
Yes.
Ms. Rajan. Yes. Chairperson Patino,
Yes.
6 in favor, 1 recused.
Thank you. Next on the master calendar are 4 removal cases, and they are 648 Broadway in New York, docket number LE0749, 870 Broadway in New York, docket number LE0750, 287 Broadway in New York, docket number LE0751, and 325 to 331 Lafayette Street in New York, docket number LE0752. There's usually no presentations for removal cases. Does anyone have any comments on these cases? Is there a motion to accept these cases? Thank you, Mr. Barowitz. Is there a second?
I'll second.
Thank you, Ms. Otto. Mr. Rivera, can you please pull the board members?
Mr. Bauer,
Yes.
Chief Hodge,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Patino.
Yes.
7 in favor.
Thank you.
Mr. Chair, before you, I know I've said this before, but we're still missing 2 members. And I wonder if this is ever going to get resolved.
It is, we're working,
Pardon?
we're working on it.
Okay, I was going to suggest that maybe the manufacturer member is not available. And maybe we ought to get the state of New York to sort of change it. To eliminate that if we can never find anybody to sit there.
The Mayor's Office of Appointments is actively reaching out to potential candidates, so hopefully we'll have an update to share soon.
Thank you.
Thank you.
Last week, last month, last week, feels like last week. Last month, there was some discussion about the residential third of the City of Yes proposal. Since then, I've gone to a couple presentations at various community groups. And as I raised in January, but hopefully it's for the commercial portion, which was a little late, but is there, I believe that this will affect us to a certain extent. It does have some provisions for expanding what constitutes living quarters. Not specifically loft. It really addresses more basement units and some other things. But Cameron, maybe you have some more insight into how we might review and discuss the information, or if we feel it would impact our work, or our work could impact the proposed rules.
When we last discussed with city planning, they said they would send somebody.
Yeah, that's what I thought.
Yeah, but I think they were doing some public rounds of presentations, so I think we're still waiting, but we'll reach out to them again.
Okay,
Yeah.
thank you.
All right, thank you. Thank you, everyone. So this will conclude our March 21st, 2024 public meeting. Our next public meeting is scheduled for April 18, 2024.